Well, PRT Lawyers, originally Perez Rodriguez, was established in 1975, and I joined the firm in 2003, becoming a partner in 2006, and the firm has now evolved into PRT to incorporate my surname as part of the partnership. And we've been involved in fintech, I would say, since early 2016, when we had been advising clients in financial services related activities, in particular funds. And in 2016, we commenced advising this particular clients who were involved in the blockchain DLT industry. And since 2018, when the regulations came into effect, there has been a tremendous increase in interest and inquiries from clients, and we have not stopped really since then, being one of the busiest summers in my 18 years of practice.
So Nick, could you perhaps please then elaborate a little bit about these expressions of interest, the kind of firms that are coming to you, and the sorts of inquiries that are being made?
Well, thankfully I'd say that we've got a wide breadth of applicants. We've got those that range from the entrepreneur himself, who's built up a capital base from perhaps being an early adopter of the Bitcoin and virtual currency industry in general, through to a more established business where they see it as a natural evolution from where they're currently based and thinking about Gibraltar as an option on the DLT side. We see the applicants also ranging in different types of complexities. We've had a lot of applicants who are quite complex in what the demands that they have in terms of what they're looking to offer to their client base. But we've also got some very simple ones in terms of evaluation of video streaming and how that can generate wealth on the DLT market for those clients. And when I was saying before about the complex ones, financial services seems to be hinging on a lot of those applications. So it doesn't just involve the DLT framework, that we're also quite experienced that as a natural evolution, and obviously based on Dalen's experience on advising on the insurance aspects and funds as well that we've done, that is certainly an advantage, because it leads on to aspects such as MiFID, which is a very important piece of legislation that has to be considered in this world.
Yes, as Nick has just said, there has to be a distinction that the activity that the company is dealing with, is the DLT aspect, is not ancillary to a regulated activity, and that has to be the distinction, as we have found that in some cases the actual activity comes within scope of MiFID II, and therefore not necessarily under the DLT regulations. And that is where we've specialized in giving detailed advice on really whether it comes within scope of MiFID II or not, and whether DLT is simply an ancillary service or activity, or it is the actual prime activity of the company, i.e. establishing a typical exchange platform.
I'd say what we roll it back to the very beginning of how we work with our clients. The first thing that we do is fully understand and evaluate what they're looking to achieve and how they are looking to achieve. And what we do is we review all of that content, and we're able to first have a discussion with them on to perhaps the best ways of pursuing what they're looking to achieve. And then it's a matter of advising them in terms of the team that they're going to be needing, not just for the application itself, because we don't just focus on the matter at hand, but we're looking to the full development, and we look to once they are fully licensed and the impact and the implications that will have on them. So it's not just the application phase. So essentially it will go through a matter of evaluation, hand-holding with the client, and then through to a pre-application phase with the FSC. But we're hand-holding them all the way, And certainly it then moves on into the aspects which are quite complex in terms of the legal opinions that Darren concentrates on heavily, because that is the crux, to be able to demonstrate how the functionality will be made in terms of the client's platforms, and showing them what documentation they need to prepare and how they need to prepare it, and the resources and time that they'll need for all of that process. And actually, as a law firm, what we're able to do is we're able to tailor their needs so as if they have the persons who are knowledgeable in, let's say, for example, on a compliance approach, so that they're able to produce those documents. And if this is an applicant who, let's say, is an early adopter of Bitcoin and has the financial background and the vision of what they want to achieve, we can also provide all the documentation working with them to be able to tailor it for them specifically. And generally what that does, it leads us through the application process with the Financial Services Commission, and ultimately taking all the way through from an in-principle decision to a full license in terms of their application.
And in terms of the fact that Gibraltar has been one of the early adopters of DLT regulations, that they've been one of the first jurisdictions to really get regulations in place, has that had an impact on the numbers of applications and people coming to you looking for advice and help?
Well, I'd say that we've been dealing with quite a number of clients who've been looking to make applications, and when they speak to us, they say that they've been considering alternate jurisdictions, whether it be Malta, Singapore, or other jurisdictions, or looking to others to make that jump as well. They've also been looking towards the UK, some clients, but I think in general they're tending to go more towards other alternatives. But I'd say that Gibraltar, not just by being a first adopter, that's not just the only reason why people have chosen to come to Gibraltar. I think it's the approach that we communicate to them, that the FSC is willing to engage with applicants, it's willing to engage with the law firms and the accounting firms who are supporting the application, and that helps because we've got associated companies that we have licensed to operate in a number of other countries within Europe. And we have experience with dealing with the financial services authorities there, and it is certainly a different approach, we can say, to dealing with the FSC.
I think that Gibraltar has managed to show that it can develop. It has a proven track record, for example, in the online gaming industry, which obviously was a phenomenon when it came out, and I think Gibraltar as a jurisdiction, together with its regulator, has shown that we can develop a new phenomenon to quite a reputable and lucrative industry, as we've done with the online gaming. And I think this is the same is happening with the fintech phenomenon. So I think Gibraltar, from its own history and experience, has been able to show that it can develop and provide that legal structure to make the industry work.